Good evening and welcome to the DeKalb County Board of Zoning Appeals. This time we'll take a roll call.
Frank Pulver.
Here.
Mary Deal. Here. Jason Carnahan.
Here.
Andrew Provines. Here. Roy Walker. Here. Andrew Cruz.
Here.
Chris Gallmer.
Here.
Meredith Wright here.
Okay, we've got
So move.
Do a roll call vote for all three, just because we'll have some abstaining.
Jason Carnahan.
Yes.
Roy Walker. Mary Deal.
I wasn't here for that one.
Frank Pulver.
yes.
Do Andrew too, but just make him abstain.
Andrew Provines.
Thank you.
Okay, approval.
You got, oh, you got two others. Okay,
We're going.
getting to,
Approval of minutes from May 13th.
I'll move to approve those as well.
I'll second that.
Jason Carnahan.
Yes.
Mary Deal.
Yes.
Roy Walker. Andrew Provines. Frank Pulver.
Yes. Okay, and then finally we have the approval of minutes from the June 10th meeting. Motion?
I'll second that.
Jason Carnahan.
I was absent that one.
Roy Walker. Mary Deal.
Yes.
Andrew Provines. Frank Pulver.
Yes. Okay, old business? None.
done.
New business, petition 24-08.
This is a petition of Christopher Frayne requesting a special exception to allow for a home enterprise per section 5.22C of the Unified Development Ordinance for a plumbing business, including office and storage. Property is located at 6772 County Road 29 in Auburn and is zoned A2 agricultural. In your packets is the staff report, a site plan showing the entire property, and then if you flip it over, it's zoomed in more to kind of where this business is more or less going to be located. He received a permit for a new house. I can't remember how long ago, but nonetheless, he's in the pictures. He's building the new house. It's completed, and then he's requesting to have the home enterprise in the house that was there towards the front. That's other highlighted in yellow. If you flip it over, you can see that kind of the north half of it's going to be used as office space, and then the storage is going to be located in the southern half of that house with storage in the barn that was there as well, with the white roof. He received permits for a privacy fence and then has proposed evergreen trees along the southern property line as well. In your packet shows kind of what the rules are for the home enterprise business. The Board of Zoning Appeals must approve or shall approve, review and approve a special exception for the occupant to conduct the home enterprise. So that's what you are here for today. So the petitioner is requesting a special exception. The office space is approximately 670 square feet, and then there is mixed storage of personal property and materials for the business. And that southern half, that's approximately 820 square feet. Has two on-site employees. One of those is his wife. And then others come and pick up materials and go to the job site. So they're coming and picking up materials, going to job sites. Nobody else is on site except to pick up materials. Proposed signage is 6 square feet on the building and then 15 square feet at the driveway. It does meet the standards of the ordinance from section 5.22C13. Hours of operation are from 7 a.m. to 4 p.m. Parking is going to be next to the building. Again, one on-site employee, his wife, lives on the property. Landscaping, again, the 6-foot privacy fence has been installed on the north and the south sides. And then evergreen shrubs are proposed on the south side, east of that existing privacy fence. That's all that I have for you right now. If you have any questions for me, I'd be glad to take them. Or if you have questions for Chris, he's here as well.
Any questions for this, Chris?
Chris one. Right, it would only be part of what's in the prohibited uses, yeah. And make sure your mic's on if you're talking to me. Dun, dun, dun. There you go. Thank you, Andrew.
Okay, Mr. Frayne, would you want to come to the microphone? State your name and address.
Is the blue light on? Turn that on, please. Thank
Chris
you.
Frayne, 6772 County Road 29, Auburn, Indiana.
He gave us a little bit of an outline. Do you have any more to add to that?
Just that we have our business there. We're still technically a pretty small business. We do a lot of new construction, so all of our work is off-site. We do stuff for Lancia, Granite, and D.R. Horton, all which build here in DeKalb County. So we've been able to help out the community a lot, and yeah, we started it in 2020 because of COVID, and it's kind of just grown into what it is now. We were able to build a new house, and so we're wanting to move the offices in the old house instead of tearing it down. We thought a nice remodel and a facelift would make that house good, make the property values even better, and give us some more space.
So the old house you're going to use as storage?
About 60% of it is storage. We took out the old kitchen, dining room, and bathrooms, and we poured concrete in that storage, and we reused the bedrooms. We took out all the livable stuff, closets, all that, and made them into just offices. So there used to be 3 bedrooms. It's 3 offices now, one for me and one for my wife. So just kind of a small little office.
Okay, the building, lack of a better description, with a white roof.
Yes. So that's our pole barn building. We built that in 2022, I believe. We had an old garage, and we were just looking for something bigger. I like to work on cars and stuff, and we're also able to store stuff for the business in there as well. So both buildings kind of have a mixed storage of our own personal stuff and business stuff as well.
Okay. I see you have a proposed privacy fence both on the north and the south.
Those are there now. Those were
they are.
those
Yes,
were
those are
permitted about,
installed.
I don't know, 3 or 4 weeks ago, 6 weeks ago maybe?
Yeah, a month and a half ago now, yeah.
So
Okay,
those are already there.
the one on the south, is that as far to the west as you can go?
Yes. So there's a county tile that we have to stay 75 feet away from. And the one on the north that's even shorter, I talked to that neighbor. Me and that neighbor get along very well. And I asked him if he wanted me to take that one out as far. It would have been harder because there's power. The main power for both of our addresses comes right there. So he said, nope, I'm good with everything. Just go to the pole there, and I'm perfectly okay with everything else.
And so when we permitted the fences, the drainage board surveyor's office doesn't allow permanent structures within that 75-foot right-of-way. A fence is considered a permanent structure. A tree is considered a permanent structure. So he wouldn't have been able to go in that 75-foot easement.
Okay. Okay. My concern is to the west of your pole barn. What is that setting outside there? Cars,
They're looking at the aerial map that
Aerial
shows
map.
the,
Oh, okay, let me grab that, sorry.
so the aerials are from 2020.
So this was
2023.
done when they were
2022.
framing the house, which would have been early
Yeah.
2023.
Yeah, there you go.
So, the pool's no longer there. Some of those vehicles are still there. 2021, we were really, really busy. We were buying cheaper vehicles. And so anything I could kind of find, because at that time I couldn't afford to go out and buy new vehicles. If I found a van for $3,000, we went and bought it and sat it out back. They all run, they all work. We're in the process of trading those in now to try to get some newer ones, but, and get rid of some of them because I have extras just kind of sitting there, but they all run, they all work. None of them are junk sitting out there.
Well, that's the concern of your neighbor to the south. I'm sure you're aware of that.
Yes.
Okay.
I know he sent a letter in. I don't know, I've never done this before, so I don't know how to like go over that letter. But some of that stuff is also not true. So I don't know if that hinders the view of anything, but some of that stuff's not true. So I don't know if we could
We'll
clear
read it
any of
into
that
the
up.
record and then
Okay,
we can call you back up if they've got questions.
okay.
Okay.
I don't have anything.
Andrew, Roy, Mary, anyone else have some questions for?
I have a few questions. Mr. Pulver had brought up the vehicles and that, but there's some equipment or supplies out. Will that all be contained inside the building, so you're not seeing?
Yes.
Okay.
So there's already less material sitting outside. Again, when this was taken, it was kind of the end of that rush of go out and get it done because we were so busy. Everyone was so busy. It's getting contained now, and the last of it's getting ready to get moved in. I've got summer help there now. They're reorganizing the barn so they can move the last of it in. So it should be in by the end of this week.
Okay. And as far as picking up materials, that typically happen early morning hours before work starts, and then they don't come back, or?
Usually they do not have to come back. We have a guy that kind of runs parts and then helps keep the barn clean and stuff like that. So if they do come, they don't come to the shop every day. Usually I have been doing on Mondays, then they come to the shop and kind of load up, reset for the week, and then go out. And then it just depends on what jobs they have. If they finish something, they might come back and pick up a part, or if they're done for the day and have extra material, they might drop it off very briefly. But
You're not talking about constant back and forth? and
no.
What are your hours of operation? Is it 7 to 4 or 7 to 7?
7 to 4.
7 to 4?
Yeah.
Okay, it just was hard to tell with,
What was that? I'm
it
sorry.
was just hard to tell in the
Oh,
writing.
yeah,
So 7
yeah.
to 4. And in all transparency, I did go out and look at this, asked for permission to walk around, and let him know that I was not able to talk to him about anything. So he went back inside and I walked around. Most of the building materials around there seem to be from the facelift that you are giving to the front building. Looked like brick facade and things like that to make it look better. Is that true?
Yes. Yeah.
Okay. And there was still some parts that were plumbing parts back there in that stack, but that will all be contained and can all be contained in both storage areas. Those will not be there
Yeah,
going
correct.
forward.
They'll all be inside. So that's what we're working on right now. I'm sure you saw there was a forklift sitting out back today. That's always inside. I don't usually leave it sit outside, but since we're in there working, trying to move stuff around, that's why that was outside as well.
Anyone else? Thank you. Anyone else in the audience wish to speak for or against? Come to the speaker. Your name and address, please.
Yes, Robin Garrison, 6789 County Road 29, across the street from this man. I've watched for about 3 years this activity over there. And for some reason, he has been infringing a little bit on my neighbor, and it has really irritated my neighbor. My neighbor has been my neighbor for over 40 years, and he is good as gold. I don't understand the relationship as what's going on with those two. But I can tell you this, I do have a serious question. This man has been operating a commercial operation out of there for well over a year. But he doesn't have any permission from you folks to do that. Is there penalties or fees for him operating without having your folks' approval?
No.
None? So we can do what we please?
He's coming before the Board of Zoning Appeals now after I think I received the complaint from you. So after I received that complaint, I did my investigations. Chris and his wife have been working with me nicely over the last, 3 or 4 months to bring the case to the BZA that has the ultimate authority over approving or denying the use. So as long as he's working with me, there's no penalties or anything like that unless we would take them to court. Our ordinance has court costs that can be assigned, but we're not taking him on the 3rd floor. We're working it out through here.
Well, just a note for you folks, however this finishes out, that neighbor I'm talking about has been good as gold with me for over 40 years. And like I said, I do not understand why all the ruckus. He actually had that man picked up by the police a few weeks ago. And I tell you, I don't consider that being a good neighbor, having somebody hauled into the police station. There's something going on, and if you folks can help with that and look at that, I would thoroughly appreciate that. That's really all I have at this time. Do I want him as a neighbor? Like I said, I'm not sure he's a good neighbor, and I would rather him not be there, my own personal opinion. Thank you.
Thank you. If you want to speak, you have to come to the microphone and give your name and address.
Marty Beasley, live at 3360 West Shadyside Road in Angola. I know Hoosier Plumbing through DeKalb High School, where I'm an employee there and a head basketball coach. And Hoosier Plumbing has been as good as gold to our school system over the last 3 years that I've been there. Donations, sponsorships for both basketball and athletic events, athletic golf events. He has bought, delivered Christmas gifts and dinners to kids that are families that are in need during Christmas time. He calls up, asks any families you know are in need. He takes care of it. Any kid that needs a job, he will hire them if able during the school year through our ICE program or in the summertime. I think he's very invested here in DeKalb and trying to make something out of our school and our kids as much as he can. And I would hate personally to see him have to move to maybe Allen County where we won't have those services anymore. That would happen. So hopefully it can get worked out here and he can make the correct requirements needed for you guys and go on and run his business. So thank you very much.
Okay, thank you.
Hello, Travis Hafledge, 724 East 7th Street here in Auburn. I'm the league president for Jackson Township Athletic Association. We're a rural youth sports league just south of Auburn. Hoosier Plumbing has been, like Mr. Beasley said, great to our youth out there. Every year they sponsor a team. If we have any issues with our plumbing, he's a phone call away and immediately is there that day taking care of our issues. I would, like Mr. Beasley said, hate to see a company like that move out of our county and support our community the way they have. So that's what I have.
Okay.
All right, thank you.
Hi, I'm Natalie Frayne. I am Christopher Frayne's wife. I live on 6772 County Road 29 in Auburn. I just like to say I'm also a nurse. I'm not on site. I work at the hospital about 2 days a week, so I'm only on site about 3 to 4 days out of the week. I didn't think we were really bothering anybody by being there. We do have a dispute with the neighbor across from us, as this gentleman was talking about. That is in criminal court getting sorted out there. And he was arrested, because he was threatening one of our employees at the time, a death threat. So that issue has been ongoing, but is getting settled out of, not here. We don't have any communication with that neighbor anymore, and hopefully that will get sorted out there. But there's not, it's been a pleasure being there and working there, and being really a part of the community. I grew up in Fort Wayne, so coming up here in Auburn and really seeing how this has developed and helping out with Jackson and getting a part of the DeKalb County school system has been, it's really nice to see, and I'm proud to be here and proud to have our kids grow. Any questions for me?
Thank you. Anyone else from the audience wish to make a comment or to speak? If not, then I'm going to close this part of the...
Sorry,
Yeah,
I'll just read the letter
yes.
that is in, you all received it in your packet, and Chris got it as well. To DeKalb County Plan Commission, subject special exception for Christopher Frayne for home enterprise per section 5.22C with the parcel number and the property, brief legal description. Dear sir, we received the above subject request for special exception and do not agree that it should be allowed for following issues. Has a lot of raw material, i.e. pipe, tubing, etc., not housed in the building. Chris Frayne current property has a 6-foot fence recently put up that only covers half of his operation, allowing sites of trash, scrap water heaters, scrap furnaces, etc. People that work for Chris Frayne speed out of his driveway along County Road 29 and pose a threat of hurting minors, I think is what it says, from Lakewood Park School and bicycle riders. Chris Frayne harasses my wife and I, wanting to buy 2 acres from us so he can expand his property. Note, this land is not accessible to County Road 29, only accessible to Chris Frayne's property. In view of the above comments, we do not agree to the special exception request. Thanks, Leroy and Darlene Jackemeyer, 6786 County Road 29. And I believe that's the neighbor to the south.
Chris, I think we had talked about giving Chris Frayne an opportunity to respond to those if he wants to.
Yeah.
To those items, just to complete the process.
You just kind of want me to go?
Whatever you want to say.
Okay.
Yeah.
So, as far as a lot of material, pipe tubing, I know you kind of walked around today. We do have the one unit still up that houses some pipe. I feel like it's pretty well contained, and like I said, that's getting moved inside. The 6-foot fence, we went over that earlier, I believe, we couldn't go back any farther as much as I would have loved to. I can't because of the county tile. We may they're going to try to fix that tile as it's broken. Once they do that, I've kind of talked to the county surveyor's office about trying to do a variance. Once they know it's nice new pipe, they might allow me to do it. But that's down the road. The trash, scrap water heaters, scrap furnaces. We don't do furnaces, so there'd be none of those. There's no scrap out there right now. I'm sure you saw that today as well. The speeding thing with Lakewood Park, I don't feel like my employees speed out of there. I'm there every morning. I'm there every afternoon when they leave. I don't feel like the speeding thing is an issue. And we don't get traffic from Lakewood Park now because it's cut off by the airport anyway. So we maybe get 20 cars down our road now a day. So, and the harassing my wife for the 2 acres, that's in some of the police reports that my wife kind of spoke about. He's upset. He gets phone calls. I'm sure you guys have all got them where people will call and say, hey, are you interested in selling your land? It might even be an old address. We get them from our old address in Fort Wayne. I believe that's what those are. I've never contacted him to buy the land. I've never reached out through a realtor. We've just never tried to buy that land. And then the land he's talking about is not actually landlocked because there's a field to the south as well. Somebody could buy the field in his property, I guess, as well. But that's not our doing. We're not. So I know my wife spoke on it. I know Mr. Garrison spoke on it. We've tried to be nice to the neighbor. He has been upset since we were allowed to build our new building. He called the county. I couldn't tell you how many times while we were building our new house about all the things we were doing wrong through Granite Ridge, legally, through the county. We've had a permit for everything we've done out on the property. I wish it wasn't the way it was because it's the county. I grew up out there. I grew up less than 2 miles from where I live today. My parents still live there. My first job was on County Road 29 at the Millers baling hay. I was in middle school, and it was one of the best jobs I've ever had. So we like where we're at. We want to stay there, and that's why we chose to move back there, and then eventually we're able to start our business.
Okay. Thank you.
Thank you.
Okay. Close that part. Anything else from any of the board members?
I drove out there as well. I didn't go on the property, but Andrew probably can attest to this, that the neighbor to the south has quite a bit of trees planted that already, I could tell from where I was driving by, it totally blocked, it seemed to, his view of any of that in the fence.
I think the only time you'd see it is if you were literally walking through the orchard.
Okay.
And if a tree is considered a permanent structure as well, there is already, and it blocks the house completely.
Right.
So.
And it looks like the trees are planted up to that drainage as well. So.
I believe he had an orchard there.
Mm-hmm. Is that what it was?
Yes, that's
okay.
what it is. Yeah. It looks like an orchard from there. Based on the concerns in the letter, though, I mean, is there any way to make this just dependent on those things truly being put in storage, actually inside the buildings?
I think you could make it a condition of approval. I even had written down that note, potentially keep, material in the building, or how we would want to word that.
Not to further restrict, but I mean, it is a valid concern. If that's one of the concerns voiced, let's just make sure it's cleaned up and stored.
Agreed.
I'm kind of stuck on the word incidental in the UDI, number 2, under home enterprise. Accompanying, but not a major part of something is what incidental means.
Yeah. Yeah.
And this is a full-fledged business.
So there's, so the primary use of the land is for them to reside there.
Okay.
So further down, even into the square footage of
The business.
area can't exceed 1,500 square feet.
Right, which the
no more
house
than
is just
one.
under 15.
Right,
Yeah.
right. So,
And it does say in
It's
the
kind of a-
location, number 6, it says, home enterprise shall be conducted entirely within the primary structure or within an accessory structure.
So it can be anywhere. I mean, as long as it's in the
Theoretically,
building.
it could be in an accessory structure,
Yeah.
which it is here.
Structures.
Right.
I think adding that as a condition
Would help you.
would help me
Yeah.
with the incidental word.
Yeah. Yeah, I understand that. And it's hard when there's, theoretically, that house that's 1,500 square feet, if it was another 1,500 square foot building, you've got equal size structures there to have a home enterprise. So I see your point there.
Okay. Go to finding the facts.
All right. Thank you. I'm going to go through the jurisdictional findings and then some proposed findings of fact. Nothing that we go through here is final until there would be a vote on it one way or the other. We'll start out with jurisdictional findings. Meredith, application completed and filed on June 11th of this year.
Yes.
Legal notice published in the Star on June 28th and affidavit given to staff.
Yes.
Certificate of mailing notices sent and receipts given to staff.
Yes.
Letter from the County Health Department dated June 25th.
Yes.
Letter from the County Highway Department dated June 12th.
Yes.
Letter from the County Surveyor or Drainage Board dated May 24th.
Yes.
And letter from the Soil and Water Conservation District dated June 12th.
Yes.
And letter from the DeKalb County Airport Authority is not applicable. So for the proposed findings of fact, we have here 5 questions, and we'll go through those, and any of you can answer some a proposed answer or more than one as you would like. Number 1, is the proposed use consistent with the purpose of the zoning district and comprehensive plan?
Proposed use is, yes, the proposed use is consistent with the district and comprehensive plan. The use is for a home enterprise which is permitted by special exception upon approval of BZA. The proposed home enterprise meets the standards of the UDO.
And any of you can discuss any of these at any time. Number 2, will the approval of this special exception request be injurious to the public health, safety, morals, and general welfare of the community?
No, the proposed use is consistent with the zoning district and comprehensive plan and will not be injurious to the surrounding community. This use is a home enterprise for a plumbing business that is all conducted off-site except for office staff and indoor storage. Also see the letters from the Board of Health, Highway Department, Soil Water Conservation District, and County Surveyor. I also want to say that I further believe that it will not be, because most of it is covered from view. You really can't tell there is a business there as you drive by. I mean, say for a couple of signs, it doesn't change the character of the area.
Number 3, is the proposed use in harmony with all adjacent land uses?
Yes, the proposal is harmonious with the surrounding land uses. Privacy fence has been installed. No additional buildings are proposed. All storage for the business indoors. Indoors.
Number 4, does the proposed use alter the character of the district?
No. No, the proposed use is for a home enterprise for a plumbing business. It is all done off-site, except for office staff and indoor storage. While this surrounding property is residential in nature, the use does not appear to alter the character of the district. This use is for a home enterprise which is permitted by special exemption from the BZA. Proposed home enterprise meets the standards of the UDO.
Number 5, does the proposed use substantially impact the property value in an adverse manner?
The proposed use for a home enterprise for a plumbing business should not substantially impact the property values.
All right. Now we have some planning staff recommendations and comments, and these are some proposed conditions of approval. These, again, are not going to be enforced unless there's a vote taken and it happens to be approved. So number 1, proposed condition that staff's recommending is that the board retains continuing jurisdiction of this special exemption to assure compliance with all terms and conditions and/or impose additional conditions deemed necessary for health and safety. Number 2, no off-site drainage crossing over said real estate should be obstructed by any development on the site. Number 3, the special exception to allow for a home enterprise for a plumbing business, including office and storage, would be approved. That language would be approved, I think, needs to be added there. And then number 4, zoning administrator to determine when conditions have been met. And then a 5th condition has been proposed here tonight along the lines of no outside storage of material, something like that. What do you think, Chris? However you...
Yeah, I think that's fine. I would just make sure that it's, if he's got his boat and boat trailer out there, that's not part of the business. That can be stored outside.
Sure. No outside storage.
Trampoline isn't considered part of the business.
Of business material,
yeah.
or something like that. Or of business supplies or something.
Yeah.
Okay.
Minimum,
What's that?
a minimum amount? of
Minimal?
storage?
Are you saying except for a
To say
minimal?
none is,
I agree with that. If he has like 20-foot lengths of pipe
yeah,
and he puts them in a rack outside that's neat, there's nothing wrong with that.
no, minimum.
Okay, except for minimal. Okay.
You all okay with that?
I'm happy with that.
Chris, are you good with that? Yes. Okay. Okay.
Okay, good.
Okay, there's no more comments. Is there a motion to approve or disapprove?
I'd make a motion to approve it.
I'll second.
Motion's been made and seconded to approve.
Jason Carnahan,
Yes.
Andrew Provines,
Yes.
Mary Deal,
Yes.
Roy Walker,
Yes.
Frank Pulver.
Yes.
Thanks, guys.
Thank you. Thank you for all of your input. All right. Second petition, 24-09.
Petition for Adam D. and Mary S. Graber requesting a development standards variance to allow for a calf staging area to be located within the rear yard setback. The structure has been built 5 feet from the property line is required, and the required setback is 10 feet. Property is located at 6108 County Road 56 in St. Joe and is zoned A2. So as you see on the staff report, zoning district A2, the minimum required setback is 10 feet. The petitioner has started the construction of a calf barn and staging area for new calves being brought onto the site for raising and mature enough to go elsewhere. Petitioner has received approval for an improvement location permit and building permit for a 10,000 square foot barn for the raising of the calves, and that barn is just north of this proposed structure. The petitioner did not have this proposed calf barn / staging area on the site plan and did not receive approval. From the site plan provided by the petitioner, it appears that south of the existing and permitted barn will be a 224-foot by 60-foot concrete paddock area that is not covered. And then south of that will be an attached 224 feet by 36 feet accessory barn that is covered, but will be, that is covered but will be bare ground, not concrete. And then east of that will be a covered unloading area 48 by 36 feet. The petitioner agreed to apply for a permit for the additional calf barn staging area, but upon investigation, it was discovered that this was about 5 feet from the property line. Thus, that petitioner is requesting the variance for the rear yard setback of 5 feet. In your packet as well, the applicant did submit information regarding the spacing needed between the existing barn and the proposed staging area. The area proposed leaves about 5% cushion over the standard between the new calves and the ones in the barn. Again, that information is in your packet. I will claim not to be an expert on that, so upon reading it, I wasn't clear on how the math works, but supposedly the maths. So anyway, they are here to explain that if you need anything further. Again, on the aerial map showing the location of where their calf barn is in red, that's what is, they did receive a permit for. That kind of holding or run area, staging area, is what did not receive permits. It was not on for us to have knowledge that it was going to be coming forward. To me, it does appear that there would be room to put it elsewhere had he let us know what was going on. But upon, discussions with Mr. Graber's attorney and The Drainage Board did review this and was all right with the drainage because it slopes east to west, not north to south. My recommendation was to approve it, but just for future, what we shouldn't be doing is approving things that are already built. We should be, especially when they receive the building permit from the get-go. So, not that we shouldn't be, but we just need to be cognizant of approving these things because it does set a precedent for future projects, especially when there's area there to put the structure.
Any comment from anybody on the board? Any questions for Chris?
So the land to the south is owned by somebody different?
Correct, owned by the neighbor to the west.
What are the options so that the BZA understands this? If it's accepted, obviously, then it's approved, there. But if it's not accepted, I mean, the building's already there, so what would you recommend as a next step?
So they would have to.
If they deny it?
If they would deny it, they would have to remove up to 5 feet of it to get it in compliance with the UDO.
Or if they want the whole size, they'd have to move it over to the area beside the barn.
Right, okay.
It is there now.
Yes.
And the neighbor says anything one way or another?
The neighbors are here. I'm sure we'll be commenting on this, but
See anything in the packet?
there was nothing in the packets. They did not submit anything in writing to me. I did have conversations with is that the crows or the crews? I can't see your
Bro, Margie.
so many cracks on that phone. But I did have conversations with them in the office and on the phone a couple times about this project. So
Okay. Any more questions for Chris? Adam Graber and/or whoever is going to speak, please.
I'm whoever. My name's Doug Johnston. I'm an attorney over in Garrett and assisting Mr. Graber and his wife with requests to this application. First, Mr. Graber's first comment to me was, I guess I needed a permit and I screwed up. I don't think it was an intentional act of defiance so much as I got the barn and I need this animal run cave or staging area, as Mr. Gomer explained. So it certainly wasn't an intended act of defiance for the rules, the zoning, et cetera. This is properly zoned. It's agricultural land. The property to the south is actually a crop field. And so there's nothing that would be impacted by the current location. And it's partially constructed. It's not complete yet, but there's over $40,000 put into this already. And it would be a substantial expense if the board were to say, sorry, move it. And so we hope that the board will understand that as an accessory run or holding area for the calves, it is an accessory to the barn. The barn does raise young calves from a certain age and weight, and the materials that were supplied were from the owners of the calves who bring them to us to grow. And the best practices in husbandry of raising calves require a lot of air so that they don't get an infection, because at their young age that can be hazardous to their development. So the outside area outside of the barn is where this is all taking place, and that is why it's a needed structure for the proper operation. And so with that said, as soon as we were advised, hey, you do need a permit for this accessory structure, we were there And we applied and hope that the board says and understands this wasn't a flouting, it was a lack of awareness by Mr. Graber. The proposed findings, and more particular, the planned recommendations, are acceptable if those are deemed part of any approval that we get. We're fully prepared to comply with those. It's our understanding that the Board of Health and the surveyor are satisfied with the structural layout in terms of how it's going to operate, that it doesn't adversely impact anything outside bounds of what agricultural property does here in DeKalb County. So we're satisfied, or we're attempting to satisfy both the board and the planning department that we'll finish this job correctly as you might approve, hopefully here this evening, and then we'll get on with our business. So happily answer any additional questions.
Do you have a number? How many calves?
300. 299. Thank you.
Yeah, because 300 is a different program.
Correct. 299.
So that's why we're doing 299.
That's true. That's true.
The number is mature equivalents, not head. So if it's calves, it doesn't qualify for the 300.
What would it be for calves then?
There isn't a number.
Oh.
Mature equivalents, and they don't assign a fractional, whatever.
So it's not like 2 calves equal 1 mature equivalent cow? Okay.
Good to know. And just so the board's aware, you can't use a financial reason to approve or deny a case. Just because he spent $40,000 doesn't mean you should automatically approve it, or it would cost him $1 million to remove it. That can't be based on your,
right.
A financial hardship or whatever is not what you should be using.
The 5 feet that's left, how do you propose to maintain that? In other words, it's in behind everything, it's growing weeds, it's junk thrown in it. How do we propose to maintain that? It's so narrow you can't get a mower through it.
Well, I don't know about the junk. I didn't personally inspect that.
No, I don't say there's junk there, but I'm just saying,
Stuff.
over years, 5 foot on a property line collects a lot of things on a farm.
It can.
If I was a neighbor, I'd be somewhat concerned about how that's maintained as far as weeds, trash, thistles.
Certainly, compliance with all applicable laws and ordinances is the standard, and that will be adhered to. You can get a mower there. It's not a big one, and it's a lot of passes, I suspect, if one tries to do it by hand, but
Okay.
There would have to be a commitment to something. That's a given.
certainly a condition of keeping it in a sightly and customary manner, consistent with, lack of vermin and infestations, those types of things are certainly appropriate.
And yes, just control of trash and weeds. It can be done with herbicides. It can be done a lot of ways.
Sure.
But no invasive species control those weeds. Just don't put anything there. If it's
Yeah,
5
it should
feet.
be, it should, for the neighbor's sake, it needs to be maintained.
No, there's not. And so that won't impede the neighbor's use. If there's a slight turnover onto that 5 feet, the neighbor still has that ability.
Any more questions? I don't. Anyone else have any more?
I don't have any at this time.
The number one problem for me is we didn't have a permit to begin with.
And an accessory run is an exception to a permit. And we respect the fact that that's a somewhat ill-defined item in the ordinance, and so rather than stand on that and say, gee, we don't need it, we're here saying with the uncertainty of the definition, let's come before the board and accept how they would like that to be handled. And so that's what brings us here today. So we can argue definitions, but we're saying, no, we don't want to argue definitions. We want to accept the position of the board and certainly the planning department.
Okay. Anybody else? Thank you.
Thank you.
Anyone else in the audience wish to speak?
Good evening. Eric Weber. I'm an attorney here in Auburn, across the street. And I'm here representing Margie Crow, now Bortner, and she's here with her husband. Margie is the owner of the properties. First of all, it's 6072 County Road 56, which I believe is to the west. That is where she and her husband reside, and then the properties that are adjacent, all of that farmland is owned by Margie, where the encroachment, the 5-foot issue exists. So if you look at the map here, all of this area underneath here is owned by Margie. Clarification. I want to go right to what I believe the point is here. Whether it was filed timely, whether this is a post development variance, all those things are interesting, but it's finding C that matters. That and that alone. Will the strict application of the terms of the Unified Development Ordinance result in practical difficulties in the use of the property involved in the petition? The answer is no. There hasn't been any evidence presented whatsoever. Even the article that's presented doesn't suggest or present any concrete evidence that there is a need to go outside of what the zoning ordinance allows for, which is 10 feet. Why do you have a zoning ordinance that has a 10-foot setback? There are reasons. Mr. Walker suggested some of them. How do you maintain? How do you ensure that there's practical space between the properties? When you have a feeding operation, again, you have a 10-foot setback for a reason. They have to demonstrate that there is some type of a practical difficulty. Their error in understanding how to do a permit, their error in understanding what was required is not a practical difficulty. Expense, as Mr. Gomer suggested, is not a hardship. Again, this could have been made smaller. It could have been made wider if they needed a certain amount of space. It could have been offset in a manner in which they took advantage of all the real estate that they own that travels this direction. A lot of real estate. They have a lot of real estate. I think this is almost 11 acres. So again, where is that finding? How do you get that? How do you get there? There's no evidence that's been presented to show, again, under number C, that the strict application of the Unified Development Ordinance would result in a practical difficulty. No practical difficulty, no hardship. They could do exactly what they want to do if they just had a little better planning. Without that, I don't see how you can find that finding in the affirmative. And if you can't find all three of these in the affirmative, I won't even go to A and B. I could make arguments for that, but I won't go there. I'll just stick with C. You can't find that, then you can't pass the variance, which, hey, been there when something's been misread. There can be mistakes, can be costly. Been there as an attorney. represented clients in that position. So I won't belabor that. Again, Margie is here. She's been a resident there, with her former husband and now Mr. Bortner, who she's married to for longer than I can remember. Again, she just wants you to follow the law and follow the findings. And all the other things are good points and interesting, but again, it's finding C that matters. So if you have any questions, I'd be happy to answer them, or anything that I could direct to Margie, I'd be happy to do so.
Any questions?
Is there a solution that's been talked about that would please the landowner in this situation, or is that, you haven't got to that point?
No, there's no solution that's been discussed. There's been discussions. I'm between the two parties, but there's not been anything arrived at. I guess, there could be solutions. There could be purchase of real estate. There could be all kinds of things, but none of those have borne any type of solution. So we're at an impasse as it relates to trying to come to an accommodation. I've not been involved in any of the discussions personally. Just been the Bortners and the Grabers, as I understand.
Rory?
Thank you.
I think there should be discussions. They should be ongoing.
So,
I feel sorry for the neighbors
and
at
we
this
can
point.
have them come and speak to that. There's been discussions that I've not been part of, but have heard secondhand, and like they say, somewhere in the middle is the truth of what actually was discussed. And I don't think the BZA should be, obviously, and I don't think you're referencing this at all, but should be the moderators between, he's got to sell him 5 feet and she's got to accept that for $5,000 or whatever. That's not what I'm suggesting you're saying. But I think that those have all been exhausted as far as when I've discussed things with their attorney, Mr. Johnston, and when I talked to Marjorie and her husband at the office. I believe those have been exhausted. I think you can ask them if that's true or not. But as far as that goes, I think, and I don't want to put words in Jason's mouth, but were you alluding to, obviously she doesn't live over by there, but is there something that is a screening or a buffer? Does she just not want to see it? Is it what's, and I trust Eric is saying that she just wants them to follow the law like she would have to if she wanted to build a building. Is it a view thing? Do we need to, obviously you've done this for many years with the city of Auburn, but doing a buffer on that side doesn't help with this variance request, but you shouldn't be giving undue conditions on something that isn't what the request is for. Doing a buffer on the west side of the property isn't fixing the 5-foot variance. But you could somehow tweak it in the words of your findings to make it work. And I just don't know if that's something that they're up for or not. Obviously, I don't want to have a 20-minute sidebar on it, but that could be something that could or could not be agreed upon. But I do think that the prop land swap thing has been exhausted, and there's just no
And
agreement
definitely
there.
as a BZA, we can't
Correct.
force a land swap. That's slightly different than offering the idea of
Right.
like Chris has before, or we have before, the idea of maybe like a tree buffer as a potential solution, and if people want to accept it, great. If they don't,
Right.
then we have to go for a discussion and vote,
Yeah.
up or down.
You want to come up, Eric? Sorry. Yep, sir. Yep.
Yeah, I think it is.
Okay, thank you. I haven't been involved in the case until after some of these discussions took place. And I think they were between the parties. But Margie has indicated that there were some discussions about trading properties or making some type of accommodation by, selling property to allow for the issue to go away. But they couldn't get on the same page with that, on where that would be. And so, again, I know she even told me that in preparation. She explained to me that there was a proposal or a suggestion that she made about doing just that, which would involve real estate, being offered in return for her receiving some real estate. And again, I won't get into all the details of it, but it was the real estate that's closer to her in exchange for some of the real estate that's behind where his calf operation would be. Now, that didn't get where it needed to go. Could that be discussed further? Possibly, but
That's also why we're here today.
that's right. My advice to her would be is I wouldn't want to do that in a recess or something. That would involve some type of a continuation of this. But that's up to you all. That's not certainly up to me, because I just couldn't advise her very well without digging into that, what all the requirements would be to subdivide, things of that nature. We'd need to talk to Mr. Gallmer about that. But yes, there were some discussions, and it hasn't been like the parties haven't talked to each other. They certainly have. They've talked a lot about the situation.
Mr. Johnson, did you want to respond? Have any more information? Go ahead.
It's a little frustrating to sit and listen to a person objecting after many conversations. And those conversations started with an approach by Mr. Graber to them saying, hey, I'm putting this structure up and I'm thinking here 5 feet off the property line. Any concern? First answer was no. Fine. He went ahead, not realizing the propriety of getting a variance. Then the conversation became, well, no, I'm okay, provided you obey the law. Okay. Well, that's exactly what's going on here today, is asking that under the law, this board grant a variance. Interestingly, it wasn't a land swap that was suggested. And I showed Mr. Gomer the map with the handwritten line by Jack saying, give me 5 acres, turned out 3 acres of land between our tracts, and then we won't complain. Now, it strikes me as odd that one would say, I'll look the other way if you give me 5 acres of land, which we all know what the pricing ranges are of land in DeKalb County. That doesn't strike me as genuine. There were discussions about meeting with the lawyer. And Mr. Graber said, fantastic. Who's your lawyer? My lawyer's Doug Johnston. I'll have him call. Refused to give a name. I couldn't have the chance to talk to Mr. Weber. We've known each other for decades. So as we sit here today to suggest that there's maybe a solution to be explored, the solutions explored were demands for land, a grab. That's what it is in its bold analysis. I hope the board doesn't think, as Mr. Gomer said, and I agree, that your job is to say, I'll take my action of the law if somebody says it's okay because I got what I want. That's not the purpose here. And it is my belief that where Mr. Graber tries to rectify his mistake, come before you, not put up barriers, not argue, just say, what do I need to do? I'll do it. And you heard me say, we accept the proposed recommendations of the planning department, that's following the law, which was the initial concern of the objector. And then it was the land. and now it's item C. Evidence was presented to the planning department about the proper agricultural way to manage this operation. We're asking for no more, we're asking for no less. We have a 5% cushion from where that thing is located. That is not a lot for straying young animals. They don't just say, here's the line, and I'm going to stay here. So a 5% cushion based on the footprint we've put in is a responsible way to run your business. And so that's all we're asking is that the board say, fine, we've got a huge farm field behind this. Granted, now it's only 5 feet instead of 10. Does that 5 feet materially affect anything other than granting a little bit of cushion to do what I want to do, which is raise? And I think the answer is this time, yes. Don't do it again. You now know. Come back if you need anything else to follow the strict reading of the order. So we would ask that the board take all of that into account when it determines the merit. And by the way, the word was used, encroachment. You understand, we're not encroaching on their property. We're on our own land. We're just not 10 feet off our property line. We're only 5. So it's sort of a backward way of talking about an encroachment. So we would ask that the board allow this variance to allow the proper husbandry of this operation in a properly zoned agricultural area. Thank you.
Doug, if I could, do you have any response to Mr. Weber's argument on C or number 3? The practical difficulties side, since the barn looks like it could be moved off to the side, the calf holding pen?
Well, if it goes
do you have any
toward
response to
the
that?
Bortners, would they want that much closer to their property? I assume not. And to the east is a pond. And so the placement was designed to put it where it's as far away from both of the potential issues. They just didn't get it far enough north. And that's bound by the barn in the open area, required by the recommendations of the owners of the calf. We didn't just make this up. Does that answer the question?
Yeah. I think what's hard is that had I known, had he come in and said, we're going to have this barn with this staging area that's going to have a structure on the back of it, he could have pushed it 5 feet north. You know, he's got room there between the other barn and where the calf barn is to push this north. The calf barn was built prior to this holding area and run area. So was that intentional? They're saying no. I don't know. Nobody knows but the good Lord above if it's true or not. So it's hard. When I was writing these proposed findings, it was hard for me to write C because I was like, how do we make this? Obviously, they have the land there, but with with what I wrote, I felt comfortable saying, yes, it's resulting in a quote unquote practical difficulty. Just wanted to get that out there.
Okay. Thank you.
Yes.
Mr. Weber?
Whatever those discussions were, my clients have told me that they never said anything of the such that you can just put this in any way you want, 5 feet on the property line. What happened was Mr. Bortner indicated, hey, look, I'm not the DeKalb County zoning administrator. I'm not the BZA. You need to do this the proper way. He learned of it because some of the construction workers were asking if they could get onto the farm property to get trucks back there or whatever they needed to do to remove the forms for the concrete. That's when he looked at it and said, boy, that seems awfully close to the property line. called Mr. Garmer about that. So, again, all this stuff about who's genuine and money grab and all this other stuff, first of all, it's not relevant. The relevancy, I mean, my clients could say the same thing. My clients could come up here and say, you know, they talked about, you know, a way to resolve it, and the Grabers asked for more, wanted to buy more real estate, wanted to get more real estate from them. I don't want to go there. That's not what the law requires. And yeah, if they go towards their property, so be it. There's a lot of room there. They could go all the way up to 10 feet. I believe. Is that the side yard setback? And if they did, they did. Hey, don't think this will be the last one. If this goes well, there'll be another barn going in. There'll be another. Hey, so be it. They're allowed to do it. But again, ignorance of the law is not a practical difficulty, nor is it a hardship. There's case law on that. And neither is an economic issue. It's just not. So we're asking that you would deny the variance.
I'd give the petitioner one last rebut.
Yeah.
Isn't that what you would do at the,
Yes.
in the court of law?
Yes, go ahead.
Mr. Attorneys? 3 of them in the room? Oh, my.
If the board's interested, I have the map drawn by Jack saying what land he wanted in his hand. You're being asked to say, for 5 feet, tell this gentleman to not follow what the owners of the calves say are best practices for raising these calves. He didn't flout this board or this county. He went and got his barn permit. All went well. He made a mistake about whether this was an accessory run or it needed an IPL, which we filed for and got, and didn't get. I mean, that's all part of this, how we do all this, and is before you. If the standard is we don't tolerate any mistakes, then where does that leave the board in the future? Is it 100% rigid? That shouldn't be where this comes down, I don't think, under these set of facts. We're in the country, we're an agricultural area. The objectors are farmers. And now they want to say, no, make my neighbor do it differently. No excuse. 100%. I just don't think that's good government management of a difficult situation that it puts everybody in. He doesn't want a war with his neighbors. He tried to work it out. I think the compromise and the recommendations of the planner are consistent with the justice and the fairness of the process of allowing that 5 feet. We're talking 1,000 feet, right? 224 times 5, whatever that math works out to be, 1,200 feet? Not 3 acres. Thank you.
All right. I think we're going to close public comment. We need to go to judicial findings, or
I think you can discuss it
You have
amongst
another comment,
yourselves.
Jason?
What's your,
Is there, they referred to this may require a permit, may not. Can you speak to the gray area that we're in, or the black and
So,
white section, of it? Or
this,
for the record?
yeah, I mean, our ordinance isn't 100% clear, but really is anything. If the laws were 100% clear, we wouldn't need the courts. There would not be attorneys.
But you don't want to go on the record saying our UDO is not at all clear.
No, it's, no, I'm not going on the record to say that. I think that, so a structure, this is a structure. It's got walls. It's going to have a roof. We don't require permits for at-grade patios. So would the concrete slab be considered an at-grade patio? I'd probably consider that a patio, even though it's going to be used for the confined feeding of the calves. But the part south of this that's going to have the roof that you see in the photos that has the walls, 6 feet, 8 feet tall, I don't know, probably 6 feet. That has to be considered a structure. There's no way to say it's not. It's going to have a roof.
Walls and a roof and a floor.
Walls and a roof.
Yeah.
So there's two sides to every story. Somewhere in the middle is the truth.
So if
I don't know.
If it was an at-grade patio, then what's the setback?
There is none.
Okay. So because it
It's exempt from those accessory structures.
because it got brought in as a structure after the fact, that's why we're in this.
Because the portion that has the roof, so there's going to be about half of it that's going to be just concrete, right?
Right.
And then this southern half is going to be the 6-foot walls with a roof. That's considered the structure.
Right. Okay.
The after the fact, it doesn't matter. And I think there's case law, and Eric has done this longer than Andrew maybe, or you can ask your dad. If
Probably a little
there might be
bit
case
longer.
law, and even if we would have found this out 10 years from now, there's case law that says you still have to follow the law with whatever that setback is. So the barn was built, it received its inspections. I think it received its final inspection. We didn't even know about it. We wouldn't know about it until we went out there again for whatever they would build next. But so the teetering of did they say yes, you can do 5 feet? No, let's have it be 4 feet. Doesn't matter. They still have to come to this board because it's not within the law.
And it's not just a concrete
slab.
patio
Right.
slab. You're talking about walls that are head high and a
Right.
roof.
Right.
Which is different.
Right.
I think, Chris, you and I talked about that before this, that it's a structure, not just an accessory patio.
Right.
So if it was flipped and the roof was on the north side,
We'd be talking differently probably,
we wouldn't have this issue.
Potentially.
arguably. But yeah,
So that's like, Chris said, it's hard. It's 5 feet too close versus 5 feet over the line. That's obvious, but it's also
We've had that.
not within our UDO. So it's hard. It's hard for me, I guess. I struggle with forgiveness instead of permission happening more and more. Would we forgive this, or would we give permission if they didn't have the wall built and they came for the variance?
So that's twofold. I mean, it depends. Sometimes it's dependent upon because they still notify the neighboring property owners within a 300-foot radius. So in this case, they still would have been notified. Sorry, I wasn't on green. They still would have been notified had they not shown up. Typically, the BZA might say, I don't even want to say typically, but sometimes the BZA will say, well, there's nobody here to object to it. We have approvals from the surveyor's office that shows there's not going to be additional runoff on the property. They're showing that there's a need for this because of whatever. But you still have to have something peculiar or practical difficulties with the use of the property involved. And again, as I've said, had Adam come forward and said, we're going to have this barn, then there's going to be this slab area that's going to be the holding, and then there's this 6-foot structure. Do we need permits for that? We just said yes. You need to move this 5 feet. And I've said this, I think, to everyone before they come on the plan commission. Typically, your staff, whether it's me or City of Auburn or Butler, Garrett, are going to try to work with those property owners to not come to the BZA. It's expensive for us. It's expensive for them. And it adds to cases that we may not need because there's room there to move this. There's room here to put this somewhere else. But I also have a conscience and feel bad that they built it without permits. So we're trying to bring this forward to the board to to make a case to approve it in light of the other departments being okay with it. But, Jason's point is a valid one that the board needs to take into consideration.
I want to piggyback off what Jason said. I'm getting a little frustrated with time and time again, people coming forward after something's been put up. I mean, it's basic knowledge that if I want to put a shed and Jason's my neighbor and, and if it's going to be close to the property line, I need to check into that. And to put up, I mean, how far below the ground does this go? I mean, is it a foundation? Is it, 3 foot?
I don't know.
5 foot? I mean, that's significant.
Probably.
That's
At least 3
something
foot.
significant to do so close to a property line without just basic knowledge, knowing you need to have approval for that. That's what I struggle with.
Anyone else? Andrew?
Yes. Oh, sorry.
The other Andrew?
The other Andrew. We'll have to work on that.
The
I'll have to
other
work on that
Andrew.
one. Yes.
No, I mean, my question about would we approve it regardless, if they came without the wall being built? And I get exactly what you're saying, but at the same time, there are a lot of people out there that still don't, they don't get it. I mean, I was right there years ago. I even called in the other day to see if I needed one for a retaining wall. I did.
But you called in.
I did.
You called in.
I did.
Probably because you know now.
And that's exactly
But, yeah.
why, because I would have not before, because you don't always think of those things or are aware. Most people don't know those things. Yeah. Yeah. Well, and that's it. It is very close to the property line.
Right.
And a difference of 5 foot.
5 foot over versus 5 foot.
Right. How far are we apart? 12 feet? I think regardless, if either way, there should be conditions on, as Rory said, maintenance, care of that. Make sure that it does not affect.
Conditions of approval, and we're not at that, so, yeah. Let's do, well, we can look at finding the facts.
I mean, in this situation, I think that it comes down to the finding of fact. I mean, you can think about all these other issues, the issues of should he have known or not have known, the issues of everything that went on. But in the end, as a BZA, you're required to somehow put all of those issues in your mind, but maybe to some extent put it aside and look at just those 3 things that are out here. And, depending on what 1 and 2 are, a lot of the argument was focused on 3. And then you have to decide based on the evidence, was there enough to sway you one way or the other on that? And then that kind of determines the vote that you're going to take. Because it has to be based upon the findings of fact ultimately.
Yeah, and your findings need to, obviously, as you see on your findings, if something is asterisked there, you have to deny it. If you mark without any asterisks, you kind of have to approve it. It's right, Andrew? It's
Basically.
more or less if you are answering in the affirmative of the questions or have a finding that
Yes.
makes that question positive, you have to approve it as well.
And
So-
sometimes there's some gray
Yeah.
areas and you have
Yeah.
to make a judgment and determination, and maybe that's where you are tonight. You have to decide one
Yeah.
way or the other. In particular, probably on number 3.
Yeah, and if you all don't agree, you're still you're basing your approval or denial vote on the majority of the findings, right? So you can create your own finding.
They're going to vote one way or the other, and there'll be 3-2 on something here, because we got 5
Correct,
votes.
but if your
so-
finding is saying let's just take number 3 because that's what was discussed. If your finding is yes, then we need to make sure that that's the way the vote goes.
Oh,
right?
sure.
That's what I'm saying.
He's saying, I may say yes to that one, and Frank may say no to that one. I think
Right,
that's
if
what
he
Chris
says
was
no,
saying.
he's going to vote no. If he's-
Right.
For any of you voting yes, it's saying yes to all 3 of them.
Right.
If you approve it, if you vote to approve.
Okay.
Maybe that's kind of
Yeah,
where you're going
that's
with
what I
that,
was-
yes. So if you vote
so
to
many
approve
words.
it, you're impliedly saying
Correct.
no to 1, no to 2, and yes to 3, basically. Okay. So are you ready to have me go through that?
Yes, sir.
Jurisdictional? All right, jurisdictional findings, and these are all proposed findings and not final until it's voted one way or the other by the BZA. Meredith, application completed and filed on June 5th.
Yes.
Legal notice published in the Star on June 28th with publisher's affidavit and receipt received.
Yes.
Certificate of mailing notices sent and receipts given to staff.
Yes.
Letter from the County Board of Health dated June 21st.
Yes.
Letter from the County Highway Department dated June 20th.
Yes.
Letter from the Soil and Water Conservation District dated June 21st.
Yes.
Letter from the County Surveyor or Drainage Board dated June 28th.
Yes.
Letter from the DeKalb County Airport Authority is not applicable. Now, these proposed findings under Section 9.09G3 of the DeKalb County Unified Development Ordinance. Number 1, will the approval of the variance request be injurious to the public health, safety, morals, and general welfare of the community? We should have some discussion on each of these. We did discuss 3 as well, but so for number 1, if any of you want to discuss that.
Says no, the proposed reduction in the rear yard setback should not be injurious to the public. The petitioner states in their application that the drainage should not be an issue as the runoff will go east and west and should not impact the neighboring properties. See letters from the various county departments without objection.
Does anyone else have any other thoughts on that particular proposed finding? You what? Okay.
I agree as well. I think it fits perfectly.
Number 2, will the use and value of the area adjacent to the property included in the variance request be affected, use and value affected in a substantially adverse manner?
No, the proposed reduction in the rear yard setback will not adversely affect the neighboring properties. The land to the south that could be affected negatively is farm ground without development. And further, it is farm ground. It is farm activities on both properties. I don't see any way that the property adjacent will be affected.
In other words, it's not a house right next door.
Not a house, it's not a development. It doesn't seem to be, as far as we know, slated for development. It is farmland next to farmland.
But it still needs to be maintained, the 5 feet does.
Agreed.
And so that's a proposed finding down a little bit further about keeping that 5-foot clean and clear of trash and unsightly weeds south of the CAF building or
That'd be
something like
like,
that.
yeah, condition of approval or whatever.
Yep. If it's approved, that would be a condition that it sounds like you guys would want to have in there if it's approved. Then we have number 3, which we've discussed as well already. Will the strict application of the terms of the Unified Development Ordinance result in practical difficulties in the use of this particular property in this way?
This says yes. The proposed reduction in the rear yard setback is needed due to the fact that the distance between the calf barn used to raise the calves and the new calf holding staging area should be maximized to help minimize the potential infection among the calves. While there appears to be the area to the east or the west of the raised barn, the petitioner built this structure without the proper permits. Upon approval from the county surveyor, this addition should have minimal impact on neighboring properties. The runoff from the concrete goes to the east and west, not to the south to the adjacent property.
If there is no more comment, anyone can make a proposal or either to approve or deny.
Sorry, Andrew.
That's okay.
Do you want to read the proposed
Oh, yes, I can.
conditions as
Proposed
well,
conditions,
just so
yes.
those are on the record
Yep.
on what's
All right. Proposed conditions, just so they're on the record. Number one, the board retains continuing jurisdiction of this from development standards variance to assure compliance with all terms, conditions, and/or impose additional conditions deemed necessary for health and safety. Number two, a development standards variance to allow the reduction in the rear yard setback to 5 feet to construct a calf barn staging area is approved, but of course that would be only if there's a vote. Number three, comply with any applicable environmental standards as required in Article 5, 5.11 EN-01 in the Unified Development Ordinance. Number four, no off-site drainage crossing over said real estate should be obstructed by any development on this site. And number five, no certificate of occupancy or certificate of completion shall be issued until the applicant files written evidence of compliance with any conditions of the DeKalb County Board of Health, Highway Department, Drainage Board, Surveyor, Airport, County Soil and Water Conservation District, or other agency as applicable. And further, where applicable, file written evidence of compliance with federal or state agencies where identified in the findings or conditions, the zoning administrator to determine when conditions have been met. And we have a proposed finding number 6, basically that the 5 foot on the south side of the calf barn in between the barn and, or the calf holding run area, between that and the south line of the property would be kept clear of trash and unsightly weeds. Now back to you for a motion
Yes,
up or
now back
down
to
by
me.
someone on the board.
In light of there being so many attorneys in the room, I would rather find some kind of middle ground before we did something and got into further litigation. That's just my opinion.
What are you thinking?
I'm not sure what that middle
Yeah.
ground is.
I'm not sure either, but I'm saying I would rather not be the reason that one side sues another side over something like that. You know what I'm saying?
But we're kind of pushed into that by the situation,
Right.
I think. Do we may have an ability to table?
You couldn't table, you could do a continuance. The continuance
may
would
not
be.
solve anything.
But the continuance would be, come back, we've done this before with cases where
Yeah.
you aren't rehearing the whole case again. Basically, you're coming back, you're saying, in this case, what Jason's, I think, recommending is that you've got a month to try to figure out something. I think they've tried that already and it's failed. I think what I'm, well, yeah.
Yeah.
So that's
I
kind of
mean,
your
you
only
ca-
point.
Theoretically, if you wanted to table it for a month, you could. It is, I don't believe that you can actually force them to do anything different or to make a deal. You can't
Right.
force that. It would give them an extra 30 days theoretically to come up with something based upon the idea that they may not know where you're going to vote.
Right. And I would prefer to see everybody, just get along, but both sides brought a lawyer to a BZA meeting. So.
Well, I mean, that's.
Which is their legal right. And
Right. I understand that.
And for the record, I would say both lawyers did a very good job of advocating
For the
their
record,
positions.
correct. I think that you've got, I mean, obviously you can make a motion for whatever you want. In doing this for now going on 14 years or whatever, I think it's going to come back and there's not going to be this kumbaya moment. We've tried that with the Amish school. We tried to have them come back with this kumbaya moment and it didn't work. We send them away and they say, oh shoot, we have that meeting next week. We need to meet. And nothing happens. So
Usually the
I think-
kumbaya moment, if it happens, will have gelled
Well-
during the meeting if it was going to happen.
and I wish they would have had that kumbaya moment 3 months ago when this was brought into place. I mean,
And that's
I
what
had
I
many
was-
emails with Mr. Johnson on these findings and him writing something that's going to support their case. And but your findings do need to support whatever your decision is.
Yes.
Meaning, what I had proposed is for a proposed approval. If
Right.
your vote is to deny it, then you need to write up and present when whoever makes the motion for an approval, you're
If it's
really
for
going to use these
approving it, you're
findings.
approving these findings.
you're
If you deny it, you
Making
need
a motion
to-
for a denial, then you need to create a finding for whatever your, what.
Right, your
what
denial
reasoning.
motion should probably say
Correct.
why you're denying it,
And
which
it
factor.
your findings have to support that finding, or your finding has to support that.
Has to be supported by the facts,
Right.
too, I mean, yeah.
Right.
Be logically supporting it.
Meaning you can't make findings. I think I don't
Or
think
you-
you're understanding.
Maybe I
me.
maybe
You
misunderstanding.
can't have a finding for number 3 that's in an approval, and you have 5
and then vote no.
votes for no, because I'm nobody to this board. I'm just
Right,
staff.
right, exactly. This
Your
is just your thoughts,
findings,
right.
your 5 findings need to support whatever decision you're going to make.
Sure.
And if it's 3 against 2, that's fine. Whoever makes the motion for approval needs to use the findings that have been discussed. If you're going to make a motion for denial,
You need to
a
decide
finding
which
needs
one.
to change somewhere because they're not
Right.
correct.
Right, yeah.
And so what I'm saying is, yeah, anyway. Go ahead.
Would you add to the third finding if you have different components that you would think would be?
Yeah, absolutely.
not-
You can do that for sure.
Yes, you could, but I would
As a
not
board.
add to I
Just
wouldn't
leave it-
add
leave
to
it
it. I
as
would
is?
just say, this is my reason for,
Well, we were asked by Mr. Weber to, prove 3, and he had stated that it's not provable. And in my thoughts here, I'm just assuming the barn, that everything was built in the most efficient way for the operation at hand. So that extra 5 foot, it's not really self-imposed. It's the most efficient way to run the operation. So,
So you could add that as a sentence to the finding if you wanted to?
right.
Yes.
The most efficient way to run the operation. So it is, practical difficulties.
That is an argument you can make, yes. I mean, it's up to you guys whether or not you agree it's based on the
A lot of that was based off
testimony.
of, the documentation here about how much was actually needed in order to do it. So it was imposed upon the applicant.
You guys are, in a sense, judging this issue. Yes, judging the facts that you heard and seen. You can make a judgment.
Based on the space requirements, I would think that regardless, even if the wall weren't built, he would probably still come for a variance.
Well, square footage on the back and square footage on the side is the same thing.
Right. But once again, I'm saying the efficiency of the operation, or the best way to lay it out for his uses.
Do we know how long this wall is?
224 feet wide,
24, I thought.
or 240 feet long, 220 feet long.
Maybe the barn was 220.
240 foot by 6 foot? or 8 foot?
224,
224.
224 feet.
224 feet long and by 6 or 8 foot high.
Yep. Sorry, we can't accept your answer. Public hearing's over.
And the reason I asked that question, which I already knew the answer, is because of what Mary said. You build a 224-foot wall, and nobody bothers to get a permit. You put down a 12 by 12 piece of concrete for a patio, 9 times out of 10, they'll have the permit.
At least ask.
224 feet of concrete. I can't make a proposal.
Well, technically, under Robert's Rules of Order, you're not supposed to in the routine running of the meeting, but you can in certain circumstances make a motion. That's my opinion
I
from
don't think
Roberts.
it's in our rules of procedure. He can't.
And I did read over Robert's rules here in the last year as county attorney a little bit and found that as you can. You shouldn't be running the meeting and making all your own motions, but if you want to in a certain circumstance, Frank, you could make your own motion. I'm just letting you know.
Pause and no motion.
Yeah, correct.
You have a motion.
Correct. Sure, absolutely. I think that's a good way of saying it.
I'm going to let one of you four make that motion. I mean, I think we've scoured it pretty well. And
I just want to make sure that whatever your vote is what your findings reflect. That's where you could.
So let's see where the motion
Yep.
goes, and then I agree, we need to make sure that when they're
Let's do a
making the
motion in a
motion.
second, and then we can discuss how your findings reflect that motion.
Or have the person making the motion say what their findings are, perhaps.
They
too.
can, but
Yeah.
really, you can make a motion, second it, and then have a discussion on the
Okay.
findings. And then let's.
I make a motion to accept it. The landowner adjacent has no recourse whatsoever.
They can.
Let me reword that. They have no options.
They can appeal the BZA's decision.
Okay, but if I make a motion to deny it,
They can appeal that BZA's
they can
decision.
appeal it or move the wall.
Anybody can. The adjoining property owners could appeal the denial if they wanted to. But the petitioner could appeal the denial. The petitioner could appeal the approval. The neighbors could appeal the approval. Any adverse decision can be appealed to the courts.
either direction.
I guess
And
not
it would go
adverse,
to
any
your
decision.
local, it would go to one of our local courts
Yep,
here.
yep, yep, yep.
I guess I'd make a motion to approve it.
With the findings as proposed?
Yes.
Okay.
We have a motion to approve. Is there a second? No second, motion dies.
Okay, guys, we gotta get to, we can't sit around in silence. Either discuss or, we can't sit here in silence for the next hour just looking at each other.
No.
And it's not my decision, but, we need to discuss or,
Can I still second that?
no, it's already died.
But you could make another motion,
I have no idea how that works.
Thank
Go
you.
ahead.
or someone
I
could
think
make a
so, 'cause
motion
as long
to
as you don't
deny
vote
it.
on it.
What?
As long as you don't vote on it, then you could make that same motion
I
again.
think you could make another motion again, yes. So you could make the motion and then Rory could second it, if that's what you wanted to do.
I'll make a motion to approve petition 24-09.
And I'll second it.
And that's with the motion to approve, Andrew, is that with the proposed findings? Or with your additional
I
finding?
would like the addition of that the operation was likely built for efficiency, so it was not a self-imposed practical difficulty.
And are you seconding his additional proposed
Yes.
finding? Okay. Did you get that down, Meredith? You need to
She's
make sure
good.
that you get that down exactly, what he said. Okay.
No.
Andrew Provines,
Yes.
Mary Deal,
No.
Roy Walker,
Yes.
Frank Pulver.
No.
So the motion fails,
Right, which
or
means,
the motion fails. So you need to go back through and do your findings
right.
to make them with what?
You're obviously wanting, three of you are obviously wanting to deny it, so you three need to propose a motion on your side, changing whatever finding you think should be changed, and then vote on that.
Are you looking for some guidance? Are you thinking, I mean,
Most of the
What's
discussion
going
has
on
been on number three, so you may want to focus on that one if you're intending to deny it.
right.
I'm stuck on the permitting. We have to set a precedence. This is happening time and time again. That's where I'm
Yeah.
at.
Precedent is where I'm at as well, that we're setting. I'm not necessarily over this, I don't know. I'm hung up on that strict application one. Because we knew we needed the permit for the building, which was first. So we should know we need a permit for a wall with a roof, which is a building, for the second step. So practical difficulty, the ordinance says if it's a building, it has to be in these regards, or you get a variance ahead of time.
It has to be 10 foot back from the
Right.
property line.
And we didn't do that ahead of time. So it sets a precedent that we can just say, oh, we didn't know, but the BZA let us fix it. When this difficulty, if it was a narrow lot and there was no sideways flexibility, then my answer is yes. But if there's room to add the square footage that they need for the ventilation, I don't disagree with that at all. There's room to add the square footage to the side instead of the back. So then the problem goes away. So it's the,
So what you're saying is there is no practical difficulties in the use of the property without this approval, is what you're saying. So that probably needs to be your finding, if that's what you're going to say. So the answer would be, what I'm hearing you say is the answer is no to number three.
correct.
Maybe no to number one and no to number two, but it's also no to number three.
Correct.
Well, if you want to make a motion that way, you can make a motion.
I don't want to deny the project either. I want to have it
Well,
both
but
sides.
you have to
of-
follow
right.
what your findings
That's
are.
why- that's
You
why I
can't make
made-
your own decision
Right.
based on your desires. I remember that's something I even heard from hearing from my father or Chris Gaumer or somebody saying that. You can't make a decision based on what you want
Right,
or
and that
what
was
you
my
feel.
suggestion for the
It has
middle.
to be this.
For the agreement between the sides to be reached.
But there is no middle here, I'm
There
afraid.
is no middle.
You have
So then
to,
then I couldn't agree with it, is what where I'm at.
Well, then you need to make a motion in that way, even though it doesn't seem like it's something you want to do. It's where the facts and your findings are leading you.
So yeah, based on the letter of the law, then my
Yes.
findings lead me to deny. So I guess my motion would be to deny the petition because of the impasse.
And are you saying like finding number one is is.
Yeah, my findings are
no
no,
is
no,
okay.
no, no, instead of no, no,
Right.
yes.
And on the third one, it's because they didn't follow, that there is no real practical difficulties, is what I'm hearing you say.
Correct.
Okay. So those are your three findings, what's written in one, what's written in two, and then the one you just articulated for three.
Correct.
And then, okay. Then it's out there to see if anybody will second it.
I second that.
Okay.
Jason Carnahan,
Yes.
Andrew Provines,
No.
Mary Deal,
Yes.
Roy Walker,
No.
Frank Pulver.
Yes.
So it's an official denial by a vote of 3-2.
Provided there's no, and I'll have to get with Andrew on this, but provided there's no appeal of the decision, we'll need to work out something as far as timing of getting this wall removed and
Yes.
moved back 5 feet. Okay?
Okay.
Correct. Thank
Yes.
you. Correct.
Yep.
At least that long, correct.
Right. Each side has an option to appeal it to a
Right.
higher authority within 30 days.
Right.
Okay.
Thanks, guys. I don't have anything for next month, so we don't have any cases that are on the docket. Nothing's been submitted by today's date, so we don't have anything for next month. So you got a little month vacation. Unless you want to come. You can, you're not going to get paid, and I won't be here.
So.
You want to? Yep.